Good morning, everyone, and welcome. We're pleased to have you with us today. We have 4 cases on the morning docket, and we will hear them in the order in which they appear. Let me remind all counsel that each side, and that's whether there's one or multiple appellants or appellees, have a total of 15 minutes for your argument. Therefore, if there's more than one attorney who's to argue, you'll have to divide that 15 minutes. Let me also remind the appellants that you may reserve up to 5 of your 15 minutes for rebuttal. So when you get to the podium, please let us know how much you wish to reserve, and we will program the clock accordingly. We are honored to have with us today Judge Arnold Golden from Memphis. As you know, the Court of Appeals is one court, even though we are elected from 3 different grand divisions, but we're honored to have him today. And later in the year, I will go to Judge McBrayer, and I go to West Tennessee and East Tennessee, and Judge Golden will also go to East Tennessee. So we travel the circuit a bit, but we're honored to have him with us today. Are there any announcements or introductions? Hearing none, call the first case, please.
Amy Leanne Wilhite versus Seth Evan Wilhite.
Good morning.
Good morning.
I am Heather Parker here for Mr. Wilhite. I'd like to reserve 5 minutes for rebuttal.
5 minutes, very good.
This case actually arises from the parties got divorced by an MDA. Thought they had everything agreed to, and then when it came to putting the tires on the road, we had some problems. So in my brief, the first thing I talk about is this finding by the trial court that my client acted in bad faith. In the brief, I go through the law of contracts and what's required for a finding of bad faith, and I think the law is pretty clear in regard to bad faith is in performance of a contract, not in the making of a contract, unless you have a contract that says you're going to act in good faith in the making of the contract. And so in this case, the act of bad faith the trial court found was this forbearance during the COVID forbearance that folks were doing for their mortgages. That happened in December of 2020. The MDA wasn't signed until April of 2021. From my opinion, I don't think that can be performance when the contract hadn't been executed yet, which means it has to be in the making, and I don't think you can have bad faith in the making because there was no provision saying we're negotiating in good faith. Number one, I think legally speaking, that's off the table. But factually speaking, in the record, there is an exhibit from February of 2021, remember the MDA signed in April of 2021, where my client sent an email to his then wife and her mortgage officer who's trying to help her refinance the loan with the information that showed the forbearance and the 0 payments due under the forbearance. So certainly he wasn't hiding it from anyone. He shared it. So even factually, I don't think we can get to bad faith on that.
The information was within the documentation, but even your banker indicated that he just didn't see it.
He didn't look at it.
He acknowledged that he received the documents, but it didn't jump off the page, so to speak.
That's correct.
Okay.
That's correct. And the actual attachments to the email should be in the exhibit, and it was 2 pages, and I think he looked at the first page and didn't look at the second page was really what his testimony was. I don't think the wife testified about whether or not she ever reviewed that exhibit.
Well, there was a provision in the MDA that said that the husband shall be responsible for the payment of the house note and utilities as per the parties' prior customs and practices. But
from my opinion, that would have been from April forward until she refinanced.
I see. So even though there was a forbearance provision in principle, that forbearance was intended to end with the execution of the MDA?
It was actually, I think, a 3-month forbearance, so it didn't have anything to do with the MDA. And even so, he was paying what was due under the mortgage. It's just that 0 was due for those months. It wasn't, he didn't make some bad act on their credit or refuse to pay. He had an agreement that he made with the mortgage company under the laws that COVID, all the new stuff that COVID created for us. And he had an agreement with the mortgage company, and he was doing what he was supposed to do. Even later, he paid that money back into court to say, look, here it is, it's here. If you need to pay it on the mortgage to get your refinance done, here's the cash for you to do that.
That fund was remitted during the time before the sale of the house?
Yes.
Okay.
Yes, I want to say it was in August, but I'm not 100% certain on that.
All right.
But any way you slice it, she didn't like that he did the forbearance, okay, but I don't think that means that he acted in bad faith and that the trial court can make a finding of bad faith, which is a legal conclusion, against him for this case.
And I believe you're hanging your hat on the fact that the tax obligation was not $78,000, but it was $90,000, and the bank said, we won't provide the loan because it's 90, not 78, or something like that.
That's correct. The record, and mostly my client's testimony, would be that it was always $90,000, and in fact, the MDA says the tax bill up to $90,000, but that he was trying to negotiate with the IRS to reduce it to $78,000, but in order to do that, he had to file a joint return with Ms. Wilhite, which she was unwilling to do. So it never was $78,000, but he gave that information to Mr. Maggart as I think I might be able to get it down to this, because he was trying to help her to be able to refinance, not because he was trying to stop her from doing that. I think a lot of that hearing and even our arguments in the briefs focus a lot on whether or not she qualified. Certainly that's a question, because that's a term in the MDA that's not defined, and whether she qualified or didn't for the loan either the first time around or the second. But I think that ignores a larger rule of contracts, which is when you're interpreting a contract, you got to interpret it as a whole so that the provisions are in harmony with one another. And the way that the trial court made its ruling, it essentially says this second part of the MDA that talks about he gets half, just means nothing. If the house sells, that doesn't mean anything. It completely ignores that provision, because they've got sort of two separate things. If she's going to refinance, here's what's going to happen. He's getting 40, and then she's going to pay these things. They split whatever's left over. That's in the first paragraph, and then the A through H sections in the MDA, which talk about the different debts that are going to be paid off with the refinance. The last one, H, is split the rest of the remaining equity. The part underneath that says if she's unable to qualify and the house will be sold, and they're going to split the net equity after paying A through G. Why would you have a separate provision that talks about if the house is sold that deals with things differently than if the house refinances, if you really just are going to do the same thing whether it's refinanced or whether it's sold?
So how was the $40,000 payment to your client supposed to work in practice then?
I think it would have been done at the closing on the refinance.
Okay.
That's certainly how the mortgage company was treating it, as a line item to be paid on the.
And then later, if the house was sold, he would still share in half the equity?
No, I think it was, if she refinances, she's going to retain ownership in whatever's there, except he's going to get $40,000, pay the debts in A through G, and then there is an H that says the remaining proceeds, net proceeds, to be split equally. But through Brian Maggart's testimony, there wasn't going to be an H, really. There wasn't going to be any money left over, because she was at the top of what she could borrow to just get his $40,000 and pay A through G. And in fact, she had negative, because once it was put in as $90,000 instead of $78,000, there wasn't enough for her to close on the loan. What it was is...
So splitting the equity, in your interpretation, only applied if the house was sold?
Not technically. I think if the house is sold, that's what the paragraph that discusses the house being sold says pay A through G, split the net equity. That's what that paragraph says. But in the first section where it talks about refinancing, A through G is paying debts, and then H says any remaining net equity to be split between the parties.
Well, in practicality, why in the world would she borrow more money so that he would get half of it and she would have to repay all of it?
She wouldn't, which is why that number is as close to zero as you can get it, but in actuality, she couldn't cover it. I think they were trying to do things based on what they anticipated, but obviously none of that came to fruition. They anticipated she was going to close in May. That didn't happen. And so,
Did the parties testify as to their intent of the contract? Because I looked at the testimony and I've missed it if they did.
I believe that, my client did give some testimony. Honestly, I don't know that the record shows that they really had any intent but that she was going to refinance. I don't know that there was a whole lot of discussion about if she doesn't refinance, she's going to sell. And I think that's kind of evident in the MDA because the refinance section is like a page and a half, and the sale section is one, maybe 8-line paragraph or something like that.
So that's why the finding of bad faith becomes so important here.
Well, I think the trial court, so let me back up a second. I'm running out of time. But my client filed a petition to sell the marital residence in August after she couldn't close in May. And that's what started all of this litigation because he was still having to pay the note and all of that stuff. If he acted in bad faith, I suppose that gives the trial court the ability to then set aside the contract, but then you have to start over. You don't just get to say, well, I'm just going to divide the funds the way that I want to do it. You've either got to go by the contract or you've got to reform the contract, which means you're reforming the assets and the debts because you're doing a new division of the marital estate. I see that I'm running out of time. I have one other thing that I wanted to say to the court about a separate issue, which is that the wife has asked for attorney's fees on appeal, and I think the law is pretty clear that if you don't put that in your statement of the issues when you begin an appeal, that you're not entitled to that relief, so I just bring that to the court's attention. I didn't file a reply brief just for that simple issue, but I would just bring that to the court's attention that I don't think she's entitled to attorney's fees on this appeal, but I'll save the remainder of my time for that.
All right, thank you, Ms. Parker. We'll hear from you on rebuttal. Good morning.
Hi, good morning. My name is Lindsay Ralston. I represent the appellee, Ms. Wilhite. I'm from the Sumner County Bar. This is my first time appearing before the court. I was actually...
Well, I'll be nice. I'm
Thank
not sure
you.
about my two colleagues, but
Thank you.
We make no promises.
So I had the pleasure of representing Ms. Wilhite at the trial in this matter. So I was actually present at the trial and the attorney of record for Ms. Wilhite. I did bring on a more experienced attorney that has handled appeals to help me in the appeal. But I'm happy to answer any questions that any of you have about the facts or the trial or the testimony.
did the parties testify as to their intent of what the contract meant?
Mr. Wilhite did. Mr. Wilhite stated over and over, we agreed to half. And the problem is, in the contract, it does not state the parties agree that he will get half the equity. While it states that his portion is $40,000, which his understanding of that is supported by other evidence that is in the record that was presented at trial, it doesn't ever state what Ms. Wilhite's portion was. And I think one of your honors picked up on the fact that was she just going to borrow some great amount so that he could get half of the true equity? Items A through H listed half of the cash equity, and both parties explained either through emails that are in evidence that were never objected to or never refuted. There's no other evidence that preponderates any different finding, that she was supposed to borrow the maximum amount that she qualified for. The following debts were going to be paid, and then anything that was left over was going to be split equally by the parties. Mr. Maggart testified, and it's supported by the emails that are in the record between Mr. Maggart, Ms. Wilhite, and Mr. Wilhite, that was going to be somewhere around $7,000. But that was based on the information that was provided by Mr. Wilhite. It is not uncommon that in a lot of marriages, there's one party that has control of the finances and one party that maybe doesn't know as much. In this case, that's exactly what happened. But Mr. Wilhite was the only one listed on the mortgage. So until the note came back or it was flagged that, hey, this is in forbearance, Ms. Wilhite didn't know. And the Empress case that was cited in our brief is really on point to this. because it talks about the concept of the intent of the parties at the time of the execution of the agreement. In the record, there's an email from Ms. Wilhite to Mr. Wilhite that both parties acknowledged, that was sent and received, where she states, I'm trying to refinance. You need to call. All you have to do is call and take the mortgage out of forbearance. Mr. Wilhite testified at trial that he knew what it took. He said all you had to do was call and make the statement that you wanted it out of forbearance. So if he was trying to help, why is there a court order that orders him call the mortgage company, tell them you want to take it out of forbearance, make the 3 timely payments? He paid them into the court. He stated he knew that they had to be paid to the mortgage company, but he didn't do that. He paid it into the court. He paid it into the court when he filed a petition after receiving a letter from my office, which is in the record, that stated, we're going to file something if you don't take action to correct this. So what does he do? He files a petition asking that the home be sold. And the court put down several orders listing obligations for Mr. Wilhite to follow so that Ms. Wilhite could get the benefit of her bargain. Unfortunately, she never did, because after he didn't put, or after he put the home in forbearance, which the argument that the court doesn't require a duty of good faith, I think that's been highly misconstrued here. All of the cases that are cited to regarding contracting and agreements, those involve agreements to agree where there wasn't a contract. Those cases were very specific that while the parties were sending letters of intent back and forth, there was never an actual contract. Here we have one. And so at the point that he was negotiating, whether he negotiated in good faith or not, when he entered into it, he knew that that home was in forbearance, yet he signed an agreement stating, I'm going to keep paying the marital bills. Opposing counsel just stood and said, well, he had to keep paying the mortgage. He never did. He paid in the 3 payments to the court, and that was it. So out of the 20 payments that he was supposed to make under the MDA, he paid 3, and that's only because the court ordered that they be paid to my trust account, and my office paid all 3 of those.
I was just getting ready to ask, wasn't the intended forbearance for 3 months only?
I don't know, Your Honor. I think it might have been 6. But when you look at that document that even Brian Maggart, who is a professional that deals with mortgages, stated that nothing flagged it for him. Nowhere on that document does it say forbearance. On the second page, it says you've promised to pay $0, and I think it has 6 months maybe listed on it. But then on the first page, it says amount due for December 1, 24. So there's no way that my client would have known based on looking at that document, and there's no other evidence that any information was given to her.
But your point is, whether the forbearance was 3 months or 6 months, the husband failed to pay the mortgage for 10 or 20 months, whatever it was.
That's correct.
Okay.
And one of their arguments is that the court should have given him credit for half of the utilities, or for all of the utilities that he paid. I believe that the trial court was much less punitive than it could have been in deciding how to divvy up the funds. But it's interesting that appellant argues that the court somehow misapplied the agreement, when if you go line by line, the court did exactly what the agreement said. And what happened in this case, as opposing counsel stated that COVID affected a lot of things, for some reason everybody started selling their homes. And so the property values in Middle Tennessee skyrocketed. There's an email in the record from Mr. Wilhite to Ms. Wilhite after she says, please just call, please make the 3 payments you're supposed to make. She didn't even ask for him to pay back the rest, just take it out of forbearance so that I can refinance. He responds with an email from Zillow, look how much we will both have if we just sell the house now. And that's the problem. That's what's caused this whole mess, is that he didn't want her to refi, because if she refied, he didn't get 40 grand at the time of the refi. There's an email, it's Exhibit 7, from Mr. Wilhite to Mr. Maggart that says, I'm writing to provide some assurance our MDA supports my $40,000 in equity is to remain in the house until the next time Amy sells the house. That wasn't Ms. Wilhite's testimony, that wasn't Mr. Maggart's testimony, that was Mr. Wilhite's testimony. He also added a chart that shows that his tax debt was, and the joint taxes were significantly higher than Ms. Wilhite's tax debt.
Counsel, let me ask you about the indebtedness to the IRS. There was one point where your client went to the IRS as an innocent spouse program and had the tax allocated. Is that correct? Between the two parties?
No, Your Honor, I believe they started filing separately.
Oh, I
And
see.
that's why, because Ms. Wilhite testified that she did not believe that he had been paying his taxes as he should. She was a homemaker for much of the marriage, had just really gotten into the workforce. And so she wasn't really involved in a lot of the taxes. I mean, this goes back to 2013. And I think she went back into the workforce maybe sometime in 2018.
Was there a levy for, on these? So was there any sort of encumbrance in favor of the IRS on the home?
Not until much later, not until May-ish. And I'm sure the court's read it, but May-ish of 2022. And then the home ultimately had to be sold. Obviously, Ms. Wilhite wanted to mitigate whatever losses there were going to be. At the time that that IRS lien hit, her debt to income, at that point, she didn't qualify. But that was after you have numerous orders saying, Mr. Wilhite, pay, or, make these 3 payments, provide the payoff. There was one instance in March of 2022 when Mr. Wilhite received the payoff on March 17th. He held it for 5 days before he sent it to his attorney. And this is all in the record with showing the dates and times of the emails. His attorney held it for at least another 7 to 8. I was out of town and the court ordered it. There's an order in there that says send it directly to F&M. Send it to Ms. Ralston and directly to F&M. They didn't do it. So I come back and send an email saying, hey, where is this? And Mr. Wilhite and his attorney email Brian Maggart and say, we're not showing up because we don't know how all this is going to be paid. Well, there was a court order saying how it was going to be paid, and it's going to be paid per the terms of the MDA. This isn't a case of a misconstruing of the MDA. This is a case of the court applied it, but Mr. Wilhite didn't like it anymore. He didn't like the MDA because the property values went up. In the Empress case, which I've previously mentioned, it states the intent at the time of the executing the agreement. So at that time, based on the value of the home, they agreed that his equity was $40,000. They did not agree that it was half. Whatever happened after that time, months later, is not relevant. If we could go back and say, well, I signed this MDA, but wow, her 401k has skyrocketed. So I don't want to agree to that anymore.
Is your argument here that the MDA is ambiguous and we need to look at these other items to construe it, or are you saying it's not ambiguous and these other items just go to the good faith component of the case?
That is correct.
Okay.
I think that these other items just promote what's in the MDA. And it's funny because if you go line item by line item where the trial court did differ from what was there, it benefited Mr. Wilhite. For instance,
Say that again, please.
where the court did defer, it benefited Mr. Wilhite. So for instance, it stated that Ms. Wilhite would receive $7,000 for repairs that needed to be made to the home because she was going to keep the home. Well, because she didn't keep the home, that wasn't allocated out of the money. So she never got that $7,000. That benefited Mr. Wilhite. So in areas where the court did sway from the agreement, it was to his benefit, which leads me to my next point. Mr. Wilhite argues that the court erred in awarding her attorney fees because he says, I won, the home was sold. That's ridiculous. The home was sold, but not because the court ordered it sold. It was sold because it had to be, because of Mr. Wilhite's circumvention of Ms. Wilhite's ability to refinance. And if he did prevail, why are we here? So the only statements in the record that Ms. Wilhite refused to cooperate with the taxes or that it was half are from the same appellant that's saying, hey, here's 8,000 words on why the court got it wrong and how I was harmed in the court getting it wrong, but oh, I won, so give me my fees. That's the only evidence that's in the record is his testimony, and the trial court obviously did not give that much weight. The court did give weight to some of his testimony in that he put the home in forbearance, and the court didn't find that he acted in bad faith. We've heard this argument that Mr. Wilhite acted in bad faith and the court erred. The court specifically said, while I'm not going to find that Mr. Wilhite acted in bad faith, I'm going to find that he did not act in good faith when he placed the mortgage on the marital home into forbearance prior to entering into the MDA. Elliott v. Elliott requires a contracting party to do nothing that will have the effect of impairing or destroying the rights of the other party to receive the benefit of the contract. And that's exactly what he did. Whether he did it intentionally or maliciously, it doesn't matter. I believe in Elliott, the parties entered into an agreement related to stock options that were going to be exercised after the divorce was final, and they both found out you can't do that. So neither of them knew. In this case, Mr. Wilhite knew. This is not a case of misconstruing of the contract. It's a case of buyer's remorse. I'm happy to answer any other questions that you may have.
Hearing none, thank you. Thank you, Ms. Ralston.
Just a few things, Your Honor. There is this issue about the bad faith and what the transcript of the ruling says and what the typed order actually says. But the court speaks through its orders. So the order says bad faith, so I have to go based on that. I did put a footnote for the court to be able to look at what the transcript actually said, which is that the judge said, this court is by no means suggesting that Mr. Wilhite acted in bad faith. But then the order comes out and says he didn't act in good faith. So
Wait a minute, you said the order said he did not act in good faith. And that's what Ms. Ralston said.
Correct. I don't think that the judge actually said that though in his ruling, but that's what ended up in the order.
But what does the order say? The
order says that he did not act in good faith.
Okay.
But the ruling says I'm finding he didn't act in bad faith. He didn't act in good faith is a finding, which is inconsistent with what the trial court actually said in its ruling. But
well, perhaps
by the time we knew that,
perhaps the judge changed his mind.
Exactly. So I have to argue what's there, what's in the order itself. Saying he didn't act in good faith, I don't know what that means other than a finding of bad faith. And the court actually did say there is an implied common law duty of good faith, which is exactly what we're talking about. And there is, but in the performance of contracts, not in the negotiating part of contracts. And to say that's different because parties are sending back letters of intent, that's exactly what we're doing when we're negotiating an MDA. We're sending letters back and forth and negotiating and marking things, and so that's what we're doing. I think if you look at Mr. Maggart's testimony, he even says that Mr. Wilhite cooperated with him and gave him what he asked for. So now this saying that my client didn't do anything that he was supposed to do with Mr. Maggart and was trying to prevent the refinance, Mr. Maggart's testimony doesn't support that. He also says in his testimony very clearly that she was borrowing the most that she could borrow for that first close, and she would not have been able to do it if the tax debt was at $90,000, which it always was. So she didn't qualify the first time around. There was no provision in the MDA that said, let her try to refinance 100 times. It said, we expect it to close on May 15th. Now, there's a lot of other language that could have been put in there to shore up some of this stuff, but it's not there. But when she couldn't close, then he says, okay, let's go to the next provision that says the house is to be sold. And he files a petition asking to enforce that provision that the house be sold. The only place that talks about the house being sold, which is what ultimately happened here, is where it says the parties will split the equity. If you look at what is in evidence and what their intent was about this $40,000, you will see that based on the home value at the time the MDA was executed, that $40,000 was half. And there's exhibits that show that they marked up what the value was and what each of them was gonna pay out of their share, so that they ended up with essentially the same amount of money. So to say,
that in the MDA though. The MDA.
it doesn't.
The MDA just says that it's agreed that the wife shall pay to the husband the sum of $40,000 for his equity
That's correct.
upon the sale. It doesn't say half of the equity. It says 40,000.
That's correct, in the section of the document that talks about the refinance. So that's at the beginning of the real property section of the MDA.
But it wasn't refinanced.
Correct. So the 40,000 doesn't come into play in our opinion. It was sold, and the paragraph, if you look at the last paragraph in the MDA that discusses this, in the event the wife is unable to qualify for refinance of the marital home shall be listed and sold, and the foregoing expenses, that's that A through H we've been talking about, shall be paid from the net proceeds with the balance divided equally. So we've either got one provision that says give him 40 and one provision that says give him half, which means it's completely ambiguous, and which one are we supposed to do?
Well, the first provision though says upon the sale. The second provision talks about the refinance.
The second one says if she's unable to qualify for the refinance, the marital home shall be listed and sold.
But the provision that provides for the 40,000
Mhm.
says for his equity in said real property upon the sale of the marital home.
And I think that's what Ms. Ralston was talking about earlier, that when she later sold it, he would get his 40,000. So I misspoke the first time that you asked me when we was gonna get his 40,000, but she told you earlier that there was an email that said he wasn't gonna get his 40,000 until his wife decided to sell the home 20 years later or whatever.
Well, it didn't say that.
It doesn't say that, but I think that was the party's intent, which is why that email got put into the record at trial.
And where it's, and in that provision where it says all remaining cash equity, that says from the refinance, and it wasn't refinanced.
Correct.
It was sold.
Correct.
And the provision that says what happens when it's sold is that he gets 40,000.
Well, there's another provision that says when it's sold shall be the balance divided equally. That's further down in that same section.
And so your argument is there's an ambiguity here.
There's either an ambiguity, or I think the only way that you can interpret this in harmony is that first paragraph, all the way down through A through H, is all based on refinance. No, that's not exactly what it says, but I think if you're looking at their intent and reading the document as a whole, you've got to take that whole first part as refinance. And then that last paragraph about if she doesn't refinance, the home is sold, that's what happens when the house sells. I think
And-
that's the only way you can read it
What
with it
was-
not being.
What was Mr. Maggart's testimony about the impact of the forbearance on the refinance? Had none, this all fell on the IRS tax debt?
No, the problem with that was it pushed their closing date. So because he said he didn't know about it in time, he wasn't real sure what to do with it because it was new. He didn't know how to resolve it. He didn't know, his testimony was, I don't know what to do with it. And so he couldn't advise them about what to do to make him be able to close the loan at that point. But,
You're talking about the tax debt now. I'm talking about the forbearance.
no, I'm talking about the forbearance.
Oh, the forbearance, okay.
Correct. He didn't know what to do with the forbearance. But if you look at his testimony, he says, if I had read that second page of the email, I would have known that there was a forbearance. I'm not quoting him, but that's what he says. He says, I didn't read it, and if I had, I would have known. And so my client can't be shouldered with the fact that her mortgage lender that she chose, that she's using to refinance, doesn't read the documents that he sends him. He can't be shouldered with that. All this other about he didn't pay this, that, or the other, I don't think any of that's really before the court right now. There's the way the judge divided it, he takes account for several different things. But as far as the debts that were supposed to be paid and different things that went on during the pendency of the case. But our main complaint is he started from the wrong point. And if you start from the right point, I think you still have to do all those things. But he started from the wrong point. He started from 40 instead of divided equally, which is the last paragraph that says if it's not refinanced, then it's sold.
All right. Thank you, Ms. Parker.
Thank you.
And Ms. Ralston for your arguments. We'll take this matter under advisement.